Right, Ryan, you packed your radar, you brought it to Vermont. Now I've got to know what's on it.
Delivering it from Vermont. It's on Congresswoman Rashida Tlaib, and one of the most important reforms to the Espionage Act that we've seen since the law was created. So the Espionage Act, which as you guys know, is a draconian and, if you ask me, unconstitutional law that is totalitarian in nature and really has no place in a free society. The Espionage Act has gone from what its name suggests, which is fighting against foreign spying on U.S. soil, to what it is now, which is a tool for the government to prosecute whistleblowers and now publishers for exposing government crimes and abuses. It's the law they're using to prosecute Julian Assange, and the same one they tried to throw at Daniel Ellsberg. Now, reforming the Espionage Act goes directly against the power of the intelligence and national security apparatus, so it's enormously difficult. But Tlaib has crafted her amendment in a way that feels impossible for reasonable people to disagree with. Now, to understand the amendment, let's walk through how the act is so vague in the first place, which is what makes it so dangerous. So Tlaib's measure amends Section 793 of Title 18, which is a reference to the Espionage Act. So if we open up the U.S. Code and head to Section 793, we find the original language. Now, Tlaib targets a handful of dangerously loose phrases in the law. One of them is, quote, whoever. In other words, it applies to everybody. The other is, quote, or reason to believe. And I'll explain why that's so dangerous. Now, the law as written applies to, quote, whoever, for the purpose of obtaining information respecting the national defense with intent or reason to believe that the information is to be used to the injury of the United States. So to take one example, Daniel Ellsberg had no intent to harm the United States. He was trying to help the American people by exposing the crimes behind the Vietnam War. But prosecutors could argue that he had, quote, reason to believe that other people would use the information, quote, to the injury of the United States. And frankly, you can make that argument about any criticism of the United States. So if you're criticizing U.S. policy and referencing classified information, that makes you guilty of breaking this law. Technically, just me referencing public information like the Snowden links or information published by WikiLeaks is a violation of the Espionage Act. So Tlaib's amendment strikes the phrase or reason to believe and replaces it with, quote, specific intent. So prosecutors would have to prove that the person breaking the Espionage Act was really doing espionage for a foreign government or some hostile terror group. Now, secondly, Tlaib goes after who can be charged for leaking and for leaking what. So Julian Assange and the editors at The Intercept or the editors at the New York Times, for instance, never took a government job and never agreed to protect classified information. That means we're all protected by the First Amendment. There's no exception to the First Amendment that says we have freedom of speech or freedom of the press, except when it's something the government doesn't want published. That would defeat the entire purpose of the First Amendment because the government can classify anything it wants with no checks or balances. And the government does classify an absurd amount of things, including things like the soup of the day at the CIA cafeteria. So Tlaib amends whoever in one section to an individual who is a covered person. In other words, somebody who has signed up to work for the government. And in another section, she changes whoever to a foreign agent who. Again, she's trying to move the law back to what it claims it's doing. She also amends the law so that only things that are, quote, properly classified are covered. An example of something properly classified would be, say, the nuclear codes. An example of something not properly classified would be the soup of the day or, say, evidence of a U.S. war crime. Now, a zealous prosecutor could still, under this amended law, charge somebody like Daniel Ellsberg or Reality Winner or Daniel Hale because they had clearances and agreed not to leak. And they could try to make an argument to a jury that they did intend to specifically harm the U.S. So Tlaib adds another important amendment. Now, under current law, a defendant like Reality Winner or Hale is banned from telling the jury why they leaked information. So the jury has no way to know if they're dealing with a whistleblower who was moved by their conscience to act. It's a piece of the law that makes it basically impossible to defend yourself. And it's why whistleblowers rarely go to trial and just plead guilty instead. So Tlaib's amendment says a defendant charged with an offense under Section 793 or 798, which is also the Espionage Act, shall be permitted to testify about their purpose for engaging in the prohibited conduct. It is an affirmative defense to a charge under Section 793 or 798 that the defendant engaged in the prohibited conduct for the purpose of disclosing to the public any violation of any law, rule, or regulation, or gross mismanagement, a gross waste of funds, an abuse of authority, or a substantial and specific danger to public health or safety. So it would be left to hear from a jury directly from a whistleblower. It would be left for a jury to hear directly from a whistleblower why they felt compelled to leak or how the public benefited from that leak. To me, that's entirely fair. If the jury hears them out and thinks that what they leaked was still dangerous and should have been kept secret, then they're within their rights to convict. But if they think the government was doing something wrong and the person acted heroically, they can acquit that whistleblower. That puts pressure on the government not to commit crimes because the chance they'll have the whistle blown goes up. Now, Emily, I suspect that if Representative Tlaib could rewrite on her own the Espionage Act, she would go a lot further than she would with this, because she doesn't want to. I don't think she wants to leave any room for whistleblowers to even have a chance at getting prosecuted. But this feels like a real attempt to get an actual conversation started and say and to put a few things on the table that are just on their face seem entirely unobjectionable. It only seems American that if somebody is charged with leaking classified information, that they should have the right from the defendant's table to tell the jury specifically why they did that. And I think a lot of people don't know that whistleblowers currently don't even have that right.
Absolutely. It seems like a very common sense rewriting of how we behave here, or how the government behaves here. And if ever there were, I think, a fertile ground for bipartisan conversation to sort of spring up about this, I think it's right now. I'd be super curious as to how Rand Paul would receive modifications along the lines of what Tlaib is proposing. There's probably a lot of room for conversation, but it does seem very common sense. And Ryan, I'm curious because a lot of people think about Daniel Ellsberg and these sort of questions, WikiLeaks, about what happens after they leak, right? The legal action that happens after the leak. But leakers, whistleblowers, I should say, I don't know why I just said leak. Whistleblowers are often, that was not like a Freudian slip or anything, but whistleblowers are often actually very savvy people who understand the law. And I'm curious from your perspective, how changes like this would they create less of a chill for people to bring forward necessary information, salient information that they think is in the public's interest that is otherwise classified? Do you think this would have a real effect on people's comfort bringing information forward?
I think it would, because I think that some people who are going to blow the whistle are just so compelled by their conscience that they're going to do it, even if it means that they spend the rest of their life in maximum security prison, and even if they know that that's a significant possibility. There are those select few number of people that exist, but that's by no means the majority of people. And so I think most people have now witnessed enough whistleblowers being prosecuted that they understand that even if they are, if they have 100% public support or 90% public support behind them, even if what they released leads to the prosecution of people for wrongdoing, that they know that they're not allowed to tell a jury that, and that if the federal government, out of spite, embarrassment, to send a message for whatever reason they decide to prosecute, that they basically can win every single one of those cases, because all they have to show a jury is this was classified information, this person released this classified information, open and shut. And oftentimes you'll find juries saying that if they had known more at the time, they would have thought about this case differently. You saw a lot of this actually as states began legalizing medical marijuana kind of in the 2000s, and the federal government was still prosecuting people that opened up medical marijuana shops, sometimes prosecuting individual patients. And you'd have these people in their 60s and 70s with cancer going to court for these marijuana charges, and they were barred from offering what's called this affirmative defense. They could not tell the jury that the reason that they were growing, say, 6 plants of marijuana in their backyard, not because they were some massive drug dealer, but because they had a state, the state had legalized medical marijuana and they were using it for their cancer under the recommendation of their doctor. And you had a bunch of juries who then, after they learned that they had convicted cancer patients, spoke out publicly and said, this is obscene. This should be overturned. We feel horrible about what we've been involved with. And so you have a similar thing here that juries want all of the information. They want to know, why did Daniel Hale release information about all the civilians who were being killed in the drone program? And then if the jury still says, this is something that should have stayed classified, they would be in the right to convict. But most juries, I think most people would say, no, the government was lying and the public had a right to know this information.
Yeah, and that's why I think it seems common sense, because litigating those questions in front of a jury actually, if anything, seems helpful. Having that conversation in front of a jury, it seems completely productive to these discussions. And I would probably disagree with you on some of the treatment of material from Assange and Snowden and all of that stuff. And, that conversation in front of a jury, that's a more productive way, I think, legally to go about litigating this. So, Ryan, thank you so much for that radar. Super interesting. People aren't talking about Tlaib's proposal, and we will get into what's on my radar after this.